Lindsay matter?
Yes, can you hear me? I'm on a different speaker than I usually do.
We can hear you.
Go ahead, Carly.
Okay. Yes, Judge. So Mr. Zandy and I have been working to get this matter resolved. I think we're about 98-ish% of the way there. At this point, we are asking for a 1-week set over in hopes that we can reach a global resolution, and if not, having maybe one issue to present next week.
Okay. So
for the purposes of today, we're going to send over ex parte to your honor a agreed order. Specifically, there's dual actions going in Cowles County Superior Court, and then there's DCS through an administrative hearing. It's also trying to do the same thing and hope to have done by next week. We're entering an agreed order we ask you to sign today so that the parties can get that out so there's no confusion moving forward. So that will likely end up on your desk here in a couple of hours if that's agreeable for you.
Was that a child support matter?
It is.
I know, I believe Miss Looney is involved in this.
Yes, Your Honor. We have filed notice of appearance in this matter, so if there's an agreed child support order, I would need to take a look at that.
Okay.
I couldn't hear you, Mr. Zandy. I'm sorry.
I'll ship this over to you momentarily.
Thank you.
All right, I'll be happy to sign off on that as soon as it makes it over ex parte, and then put any remaining matters over 1 week, and that would be to the 26th at 1 o'clock.
Perfect. Thank you, Judge.
Lawrence is present. Welcome.
Good afternoon, Your Honor. Yeah, I don't know that mom or dad are here. It doesn't look like it, but it's a compliance hearing. We have all met prior to Miss Tenna going into jail for a few days from drug court. She's working on her sobriety, and dad's working with the kids. So everything is on board and on track.
Okay. It looks like I was going to be reviewing a child support issue, but it looks like there was a declaration filed by Ms. Tina on that has not made it into Odyssey yet. So I haven't been able to address that. Is he, Mr. Olmos, are you present here today?
It does not look like it.
I
know mom knew that court was, but I hadn't talked with dad for a couple of days. So
he's just coming in now.
Okay, good deal.
As well as Ms. Tina.
And there's George.
All right, so we're talking about the Olmos and Tina matter. Just advising the Guardian, it looks like everything is good to go there, so we've completed that review. I've not been able to review the financial declaration that Ms. Tina filed. That has not made it all the way into Odyssey yet, so I can't address any child support issues today. I can probably set that over either 1 week or 2 weeks, whichever works best for the parties to address that. It's been filed, it just hasn't made it to where I can look at it yet, so.
Your Honor, I'm spending $600 supervised visits.
I couldn't quite hear that.
And I have to pay rent, so I mean.
I'm here, sorry.
All right, so again, I've not been able to review Ms. Tina's financial declaration. It's in Odyssey, but it hasn't made it to where I can actually see it. So it's been filed like I advised her to do. I can set this over 1 or 2 weeks so that I can at least look at that and then make an informed decision as to what child support may or may not be. But I can't make that decision today because I don't have the numbers in front of me. So which would work better for the two of you, 1 or 2 weeks?
I mean, as soon as I can get help, the better. I mean, I went and filed my taxes and found out that Miss Tenna claimed our children on her taxes, which was kind of like my saving grace there.
I only claimed 2 of the children.
Okay.
I wasn't aware.
Right.
Which she claimed, or what's going on with that?
Well, I claimed my oldest child, who is not his, and I claimed our youngest son.
Okay, so he can claim these children?
He can claim Trinity and Jared.
Okay.
Well, I take care of all 4 of the children by myself.
I took care of them up until I was kicked out of the home.
Well, hold on, folks. I can't make a ruling on child support till I get my eyes on the declaration, so I can work through the calculation on that. So I can put this over 1 week to the 26th if you like, or 2 weeks to the 2nd.
Are we?
Is next week?
Tuesdays or Thursdays our visits with the kids, though, unless something's changing today.
You're going to be talking with the guardian ad litem, and she will make some recommendations about that. And if there's a need for a temporary change, we can certainly address that, but I'm not addressing any changes on that today.
Okay.
So do you want next week or 2 weeks?
Next week. I mean, the sooner the better. Like I said, I need help. I've needed help for a long time.
All right.
I do use my food stamps and to buy them Walmart orders and stuff like that. So I mean, I'm helping as much as I can.
Okay, well, I can't make a ruling on it until I see the declaration. So I'll put it over 1 week to the 26th, and then we'll address the child support issue. Okay. And then if you work with the guardian ad litem, and if she's got a recommendation that we need to make some changes on a short-term basis, we can certainly do that. All right.
Today or next week?
Okay, so we're back on the 26th at 1 o'clock, and we'll deal with child support. And then it looks like we have a review set with Ms. Lawrence on May 14th for an interim review. Is that right?
Correct.
Okay. All right. And if you, Ms. Lawrence, if you do see, once you get into this, if it looks like that we need to do any adjustments with what the current situation is, just have the parties put it back on.
Okay, will do.
Okay.
Thank you, Your Honor.
You're welcome. So I'll see you back next week on the child support.
Yep.
Okay.
Again,
Thank you, Your Honor.
this is a challenging case for me because I've got an awful lot of information in my head that probably is not admissible in this case, but I'm not sure I can ignore it as far as what's been presented in this matter. So given that, I'll hear from the parties on temporary orders.
So this is my client, Alicia Nelson's motion for temporary orders. I'm Noelle McLean. I represent Alicia Nelson, the petitioner in this matter. I do note that I did receive a late financial declaration. My client has not had an opportunity to respond to Mr. Prowell's late financial declaration, and I would ask that the court either not consider that or alternatively that the court allow me some leeway in regards to argument from that documentation. And as you indicated, we are concerned about the court considering hearsay evidence claimed by Mr. Prowell and his witnesses as it relates to the issues that are before the court. These folks have been together for approximately 8 years. They do have 2 children as issue of their relationship. Mia is currently 2 years old and Owen is 5 years old. Ms. Nelson has been the primary parent for these children. And these folks, as my client tells you, they had a prior separation during which time there was an administrative child support order that was established for Owen. And then when the parties separated most recently in August of 2023, the state has been attempting to serve, and I think only recently served Mr. Prowell with an administrative action for Mia. So there has been no financial support provided for Mia. There's only been whatever the state's been able to garnish under the old administrative order for Owen. There's been no support contributed by Mr. Prowell for work-related daycare or other expenses for the children since these parties separated. I note that he claims in his declarations and elsewhere that he has been paying the home mortgage. He has provided absolutely no proof of that. My client tells you that she's actually had to cash out her investment in order to bring the home mortgage current and to provide payment. And that is a substantial amount and obviously is important to provide a consistency for the children. At the time of the parties' separation, my client was essentially self-employed in this farming business that they were running from the household. That clearly, when you review through the tax returns, did not provide a wage that would support my client, these children, and this household. And so as soon as these parties separated, my client worked on obtaining employment, and she is currently full-time employed as a licensed practical nurse. These parties, as I indicated, separated in August, and there was a protection order, obviously, that Your Honor heard and ultimately granted. Mr. Prowell has not had physical contact with the children since their separation in August. Mr. Prowell goes on to make, I would suggest, unsubstantiated allegations of parenting or 191 factors against my client. I see this more as an attempted defense, given the fact that there was this protection order entered, that these folks have had a tumultuous relationship. And I think the fact that speaks the loudest as it relates to parenting these children is the fact that Mr. Prawl is gone 9 to 11 months of the year. If you go back to his declaration, he tells you he is on a fishing boat in Alaska from 4.5 to 5.5 months twice per year. So that means he's removed from these children's lives for 9 to 11 months, which is significant when we're talking about a 2-year-old and a 5-year-old. My client has, again, been the primary parent, providing for their housing, their food, their daycare, their emotional support, spiritual support, extracurricular activities, medical. She's been doing it all. And then he and his witnesses come in and make allegations that my client has, been feeding the children food on the floor, has been, abusive. If you go back and look at those declarations, I would argue that those declarations, weight should not be given to those declarations. The declarations do not outline specific timelines for the most part. They do not identify, when these people had contact. My client tells you, for example, that his family has had limited contact over the years. His mother, Marcia, has had contact approximately 3 to 5 times per year for a couple of hours at most. His sister, Megan, has had contact with the children approximately 2 to 3 times per year, typically around the holidays. When you go back to Ms. Collins's declaration, you'll note that her declaration provides no information supporting the sufficiency of her statements. She provides no history on how often she had contacts, what years she had contacts, where she had contacts. She provides 5 specific instances from 2020, 2021, and 3 different instances from 2023. The 3 different instances from 2023 were related to property division surrounding their grandfather's truck and what she identifies as Mr. Prawl's truck. The prior 2 instances were before Mia was even born. And I would note that the courthouse doors certainly have not been closed to Mr. Prawl. If he was so incensed about his lack of contact with his children, he would have come to the courthouse, he would have filed this action. But it's in fact my client who has come to the courthouse and requested entry of a parenting plan, requested entry of a protection order, because she's the one that needs to have some consistency for these children and ensure that the topsy-turviness that Mr. Prawl incites into this family is not going to continue. Ms. Pogue is the current daycare provider with the children. She currently lives with my client. She's been living with her since February. She has provided an observation of her interactions with Ms. Nelson and the children. She finds her to be an appropriate parent. We've provided photographs of Ms. Nelson's home that shows that it is tidy, that it is appropriate for these children. And what's most concerning is that Your Honor entered this protection order. The protection order stated specifically, and I don't want to misquote, so let me grab that real quick. The protection order specifically stated that he is to have no contact with my client, except contact via the domestic relations case regarding the children is not a violation, nor is any visitation incidental contact a violation. As we sit here, there is no order currently entered relative to visitation. That's why we're here. We're asking the court to enter specific orders. And yet you have Mr. Prawl engaging and communicating with my client in regards to FaceTime calls. And Ms. Pogue tells you about one specific FaceTime call most recently where she had been watching the children, and Mia, 2-year-old Mia, takes a washable Crayola marker and marks her face. And Mr. Prawl goes on a verbal tirade against Ms. Nelson over that phone call. 1, that's a violation of the protection order. 2, it's totally inappropriate behavior in front of your minor children to engage in. Both my client and Ms. Pogue also talk about Mr. Prawl's relationship as a step parent to my client's oldest child, and how the oldest child after he has communications with Mr. Prawl is very disrespectful to both my client, to Ms. Pogue, and towards the other children. Certainly, from what my client has outlined, we have concerns relative to Mr. Pogue's domestic violence. We have concerns about his substance abuse. He is an habitual offender when it comes to driving. We don't have verifiable information that indicates he's working on getting his license back, but he does not deny that he has driven with these children, even though he does not have a valid license and has not had valid automobile insurance for years. Again, very concerning when you're talking about parental judgment. So we're asking the court to first appoint a guardian ad litem. We think that a guardian ad litem is appropriate in this case. I would note that I was on the docket this morning, and Judge Hahn advised that April 30th is, I believe that's spring court or spring judicial conference. My proposed guardian ad litem order set forth the 30-day review, compliance GAL review for April 30th. I was not aware that that was spring judicial conference. So ultimately, that would need to be changed. And I would propose, assuming council doesn't have any conflicts with May 7, just kicking that a week for May 7. So that would need to be changed on page 3 of that guardian ad litem order. But we do think that it is appropriate for a guardian ad litem to be appointed in this case. We are asking the court to order that Mr. Prawl undergo a collateralized domestic violence evaluation, as well as a collateralized substance abuse evaluation. Those are both outlined in paragraph 4 of my client's amended proposed parenting plan and the proposed temporary order parenting plan. That's at paragraph 4B. We are also proposing that there be supervised visitation through reconnecting families until we can get some additional information from a guardian ad litem. That should be at Mr. Prawl's expense, and that should be through reconnecting families visitation services. It was my understanding, according to my client's declaration, that Mr. Prawl was returning back to Alaska after the first week of March. It appears that he's there in the courtroom. So I don't know what he's done as far as his work or his employment, but I understood that he would be returning and therefore was not available. I don't know how long he is available, but if we can arrange for supervised visitation through reconnecting families, then we can do that while he's here. We're also asking that the court enter protections, and these are outlined in paragraph 4A2, that allows my client to request random drug testing, that he is to be restrained or enjoined from consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider, that both of them should be restrained and enjoined from talking negatively or allowing third parties to talk negatively about the other parent, that the father should not use any type of corporal or physical punishment on the children, and that only licensed and insured drivers should transport the children. Again, we believe that that is appropriate in light of the domestic violence and concerns that, and substance abuse concerns that we have regarding Mr. Prawl. In regards to the finances, as I indicated, my client is an LPN. We provided proof of her income. Her monthly net is approximately $5,029 per month. And if I recall correctly, she's been employed since October 1. That's when she was able to secure employment. Mr. Prawl works, as I indicated, 9 to 11 months a year. When he's not employed during the fisheries, it's my understanding that he receives unemployment. And I have calculated his net income based upon his earnings as well as his unemployment at an average of $7,691 per month. We are asking the court to set child support at $1,440 per month. We're asking that the court set that effective January 1 of 2024, and that the court, and that's because my client filed her petition with the court back on December 21 of 2023. So we believe it would be appropriate to start at least January 1. We're also asking that the court reserve back child support or child support prior to the filing date, and from the date of the party separation pursuant to RCW 26.26B.040. And if you take a look at my proposed child support order, you'll see that language at paragraph 25B. And the statute allows for essentially a 5-year look back for purposes of child support. Finally, we do believe that Mr. Prawl should also be responsible for his proportionate share of work-related daycare. My client tells you that she currently has approximately $1,600 per month in work-related daycare, and as well as he should pay his percentage of uninsured healthcare expenses and preschool expenses. Finally, my client is requesting a contribution towards her attorney's fees in the amount of $2,500, given the disparities between the parties' incomes and the lack of financial support since these folks have separated.
Counsel, can you help me understand the calculation? Because I came up with completely different numbers for both parties than either counsel have done. So I don't know how the calculation was done to get to the incomes.
Yes. So if you go back to,
I looked at the 2023 tax return as well as the, I didn't have that for your client, but I had it for him as well as the unemployment.
So we provided my client's 2022 tax return. She has not filed for 2023 at this juncture, I don't believe. We provided her wage stub, her year-end wage stub for December 22 of 2023. And again, taking into consideration that she didn't commence this job until October 1. So if you'll bear with me just 1 minute, let me go. I'm pretty sure I used her hourly, but let me go back to my calculation in specifics. So I had 6501 as a gross, and let me just double check and make sure. So her hourly is 37.51 an hour. Yeah, so that's what I did. So I took $37.51 an hour times 40 hours times 52 weeks divided by 12 is $6,501.73. So that's how I arrived at her gross. And then from that, I allowed the computer to deduct federal taxes based on her filing. I ran them both filing single. I ran her FICA according to the computer. And then for state industrial, what that comprises, because the worksheets don't provide for Washington family medical leave, for Washington long-term insurance, or for workers' comp, pardon me. For workers' comp, I just lumped all of those together. That's the $97.16 that you see as far as the deduction. And then she also pays mandatory union dues, which are $126.77 on average from her wage stub. So that's how I arrived at her net. As it relates to his income information, we had his year-end wage stub and his W-2s for 2023. And so I took his 2023 and his 1099 for his unemployment. And that's how I ran his. So let's see, in 2023, he grossed, according to his year-end wage stub, he grossed $98,506.52. And then according to his 1099 for his unemployment, he grossed $12,167. And so,
and counsel misspoke. It's 96,330, not 98.
His wage stub indicates that he got 98,000.
I'm looking at his 2023 W-2, 96,330.33.
I'm looking at his wage stub, which shows $98,506.52. I can't explain the difference between those.
I'm not sure what she means by a wage stub, but she means a pay stub or a W.
Page 6 of our sealed financial source document is his pay stub. Wage stub, pay stub, same thing.
Yeah, I'm not sure, Your Honor, because page 6 of their sealed source is her pay stub. So I'm not sure what they're looking at.
No, page 6 is Aleutian Longline LLC. It's dated December 29th of 2023, and his name, Lucas Prawl.
Is it your second sealed source or your first sealed source?
First sealed source.
The first sealed source, page 6. I apologize. I see Alicia's. Then the next thing I see is an unofficial transcript.
Yep, and then the next page.
Okay.
Should at the bottom of it say page 6.
Okay. I think I apologize, Miss McLean. I was going off PDF pages, which includes your cover sheet. Thank you for clarification.
Sure.
Okay.
I see, those are essentially the same numbers, but I'm just coming up with different nets based on the calculation for both.
Well, as I indicated, I allowed the computer to run both of them as single. And then, sorry, I have to go back to my passport. And then I ran so again, state industrial insurance deductions would include the lump for paid family medical leave under Washington State, long-term insurance under Washington State, and workers' comp. But if you go back to his wage stub, they do collect for medical and Washington medical and family leave, and then the Washington cares. So they identify those. They do not collect for workers' comp. So you don't see a workers' comp withhold from them. So I took it off of his wage stub as far as what the employer withheld from him and divided that by 12 to arrive at my $61.13 deduction for him.
Okay. Let me hear from Ms. Jocelyn. I'll see if I can square the numbers out with myself.
Thank you.
May I just make one other clarification? The other thing is I would just remind, and I'm pretty sure that I did this, and I'll double check my numbers, but Washington State held off on collecting the CARES monies until July. And so that number on year to date would have been divided by 6 rather than 12. Does that make sense? So in other words, Washington CARES deductions started July 1 of 2023. So anybody's wage stubs in 2023, that only represents half the year's withholding. So if you extrapolate that, then the full year for him, for example, would have been $320.29 for the whole year.
Okay.
Agreed. Started July 2023 at 0.58%. So no argument from me on that. Okay, I will try to be brief, but we do have a lot to go over regarding any allegations of not having specific timeframes or not specific enough for opposing counsel. We do have 2 witnesses in the courtroom. We have Miss Collins. We also have my client's mother who can attest to anything regarding trying to contact and any issues related to to Megan's declaration. Regarding the mortgage, it seems like it's a he said, she said. I mean, she's sitting here trying to say we need to prove all of our payments, yet she's not sitting here proving all of her payments. Yes, my client acknowledges she did make a few payments to catch up. Majority of the time, he's the one been paying for it. He's been out of work since December, so he hasn't been able, his last payment he made was in December. Regarding the 191 factors and not being substantiated, we have third-party declarations. We have 2 witnesses present. We have CPS reports. They certainly substantiate what is in there. I think it's kind of, I think my client's going to take a little offense to the fact of opposing counsel stating what he should or shouldn't have done. My client's out here fishing for 10 plus months out of the year trying to provide for his family. He can't just as easily run to the courthouse where opposing party can. Additionally, she didn't do the same thing either. She didn't avail herself to the courthouse when alleged abuse happened or she allegedly needed a parenting plan. So neither party did this. I don't think we should be telling party what they have to do when. Your client didn't do anything either, and she certainly has more of an ability to do it. Regarding the contacting, my client agrees he can contact her regarding the parenting plan case regarding the parenting plan case. That's what he was doing. The order doesn't say there have to be a plan in place. It says per the case. So that's why he reached out in order to set something up. Again, she refused visits. Regarding the license, he has 2 more years until he's eligible to get that. He has licensed and insured drivers that are providing any and all transportation from him. Regarding the babysitter, that's her babysitter. I think this is a live-in babysitter. I don't know if she's being charged rent. So to me, that's some bias that's presented. Regarding any alleged supervised visits, as I'll explain in a minute, one, it's not necessary. She never asked for supervised visits until all of a sudden she got counsel, and all of a sudden it changed from there's nothing wrong with my client having visits, the kids don't need to be on a DV order, to now all of a sudden, oh, he needs supervised visits. So had she had thought that, why wasn't that pled earlier? So going over from my client's position, his response, timeline's fairly similar in terms of when they got together. They got together in 2016. Whenever he's home, he does the typical parenting, raising the kids. He even has raised her eldest son, Landon, as his own child and loves him dearly and is actually quite distraught that she's cut off all communication. He's done all of the parenting, the feeding, the school, taking Owen and Landon to school. Additionally, he's done everything that he can. He would be in contact with them every single day. And then when he couldn't actually speak due to a connection with fishing, he was reaching out to Alicia via Facebook message to find out how the kids were. The party separated around September 7th, 2023, and that was due to her oldest son finding her in bed with another man. That generated a CPS. It didn't interrupt Ms. McLean.
I'm interposing an objection.
I did, and so
inappropriate in these types of actions.
There was nothing raised in her responsive declaration about this.
Stop. Let me rule. Let me hear the objection first. Ms. McLean, what is the objection?
Objection is to fault not being considered.
This is a no fault state.
Yeah, it's not about fault. It's just stating why they separated. So it's just simply acknowledging the time frame for why they separated, and it coincides with the report. My client's there. He can testify. We're not saying we know it's a no fault state. It doesn't matter why, but that is substantiating the date of their separation, which was September 7th.
All right. For that purpose only, I'll allow it.
They keep raising over and over, my client hasn't seen the child since August. My client was fishing and returned home in December. It is solely due to Alicia that he hasn't seen the children. He came home December 20th, 2023, and she had a second protection order in place. This was after she already had one protection order that was dismissed because she failed to show up. That is why he has tried to see the children, which I will go into a minute. They're acting as if my client just took off to Vancouver and said, peace out, children, I don't want to see you. That is not the case. It is Alicia's refusal, which is why he hasn't seen them. We have even tried out, my client's mother tried to reach out. I tried to reach out to set up visits. We got, here's a couple of hours of supervised and you get one phone call a week. It was only when my client came home in December did all of a sudden all of these alleged issues, domestic violence occur. All of a sudden, my client's not a parent. He's not around. He's never been with them. That only happened after that September incident. And when my client got home, she went to go file a protection order a few days or to coincide so it would be set up in place when my client was home. She didn't need to go in August because he wasn't there. But if she was really concerned, why didn't she go? So she hasn't listed the children on the protection order. She didn't list them on the first one that got dismissed. She didn't list them on the second petition that is in place. If there was legitimate concerns, why weren't the children listed? If the children allegedly saw these alleged DV incidences, why weren't the children listed so that they could also be protected parties? As we've stated, my client lives in a 5-bedroom home and the children would have their own room in privacy. I have 3 witnesses in the courtroom who can attest to the living situation and that the children would have their own room. There's nothing
I'm going to object to objection.
Counsel, what is the objection?
Information outside the scope of the declarations.
It is not. It's in my declaration. It's in our client's responsive declaration that he lives in a 5-bedroom house and there's room for the children. It's not outside the scope.
What is the issue that I guess I'm not understanding the objection.
It's my I did not recall him saying anything about the sufficiency of the home.
Yep, it's in there because they even actually responded to the fact that he lives in a 5-bedroom home. So it's in our declaration, and they in fact responded to it.
Declaration, because that was, I believe that's in there.
It is in there. It's where I got the statement from. So regarding the home, Your Honor, I don't know if you've ruled or not. I apologize.
Rule the objection to the 5-bedroom home issue.
Okay, thank you, Your Honor. So he does live in that 5-bedroom home. He has testified in his declaration that the children would have their own room. He does work, as stated, 4.5 to 5.5 months at a time, 16-hour days. He's generally home approximately 7 weeks in the summer and 3 weeks during December, which always includes Christmas week. He never works Christmas week. I do think it's important that we take some time to go over these 191 allegations, and it'll also, I think, and we've agreed that a GAL is appropriate, so there's no argument from us on a GAL. GAL needs to look at these allegations from both sides, but we do have the neglect issues. We have my client who's been on the phone, who's heard Alicia Alicia has said to him, "I'm running errands in the store, the children are in the car." So she's told him, she's told her friends this. See, there was a CPS case for her son Landon about, I think, 10 years ago at Wilco Farms when a passerby saw him left in a car, called the police, and CPS were called. We have witnesses who have written declarations that she does, in fact, pour cereal out on the floor and has her kids eat the cereal off the floor. My client, we have people who have said they've witnessed that she leaves in the car to the point of crying, her mother. She's forbid her mother up until February for seeing the children, and in fact made her mother leave her own house for Christmas because Alicia didn't want her mother there so she could bring the children over. My client has severe concerns regarding her alcohol abuse. We have a declaration that states he has seen her drinking on the way home from the children in the car and has witnessed her mental and emotional abuse from her. That was the declaration of John Margetta. We have her sister who has witnessed her drinking while she was pregnant. Or breastfeeding, I apologize, not pregnant. My client has seen her get out of the car with open containers, get out of the car after drinking from driving home with open containers, and basically stated the last 1.5 years in their relationship, her drinking was so bad he doesn't remember a day that she wasn't impaired, not drinking, impaired. There are 3 CPS cases, and I think, again, this will be key for the GAL to look into. The one in September we just mentioned earlier. Second one, November and December, when the paramedics were called because somebody was passed out at her house and they had an overdose on inhalants. CPS said, don't have that person around the children, and she continues to do so. And then we have the third case, which just started in December 2023 with her friend of over 30 years, Sadie, which I think will be key that the GAL talks to, who states that Alicia has been driving drunk multiple times, leaves the children in the car, passed out on her deck drunk in 30-degree weather, constantly shows up drunk, animal feces in the house, et cetera, et cetera. This is something that is prime for a GAL to investigate further. She's emotionally abusive to him and the children. She's very manic. She screams. She creates these fake profiles to harass people on Facebook. She's demanded that her eldest son not tell Lucas about that September incident. She has withheld the children. My clients testified all the attempts that he's made to see her, and she hasn't let him see the children. We have his mother who tried to set up visits on the December 20, 22, 24, 27, January 5, 22, and February 7, and she refused. We tried to set up visits, and the response was abuse supervised. We tried to set up phone calls, and they said, you can have one a week. We also have the issues with the DV, where she's kicked him, thrown stuff at him, verbally abused him. Basically, she gets in the mood. If she's got something around she can throw, she's throwing it. We have the incident in summer 22 when she picked a fight, and my client refused to engage with him. She followed him around for hours, antagonizing him, and she had to call the police. So the court, opposing counsel, a GAL, somebody might question why, with all of these issues, would my client leave the children with her? The issue is there's no other option, which is very sad. There's no other option. His family doesn't have, can't take guardianship. Miss Collins isn't able to take guardianship. His mother, unfortunately, isn't able to take guardianship. So my client is hopeful with the evaluations that we've requested that she's simply going to get some help for her and her children so that the children are safe and we're not looking at these children getting pulled out of home. Regarding her motion, I mean, the rest of it it's just simply allegations. There's nothing there to back them up. She makes these, one-off comments about he's never been there, he's not there, when he's home for those solid periods of time. And when he's home, she's out girls' night drinking 3 to 4 nights a week. My client is very open about the issues with the DUI. He's not trying to hide them. He's not trying to make light of them. He admits he's had 4. The first were in 2000 and 2003. After that, he was sober. No alcohol, no marijuana, nothing. Sober for 8 years. Unfortunately, he had a very horrific accident at work. He didn't stub his finger. He didn't cut his fingertip off. He took a fish hook to the eye and almost lost his eye. He went in surgeries, multiple years of surgeries, recouping and everything. And I'm not saying that that is a reason or excuse, but he fell off the wagon. He admits he fell off the wagon and ended up getting 2 more DUIs. That was 8 years ago. We're not discounting it. He's done it. He's acknowledged it. He's not trying to hide it, but people do recover. We can't sit here and be like, you got a DUI 20 years ago and here, and all of a sudden you're this terrible person, alcoholic that's driving around. He has done what he needs to do to improve himself. And my client takes no issue if he has to take, if the GAL wants him to take a UA. He rarely drinks. If he does, it's a beer or 2 here or there. And he realized the 2 of them, Alicia and him, it's just toxic if they're drinking together. Physical abuse, I don't think we need to go into that. Your Honor heard this. He's in denial with it. Regarding support, he certainly didn't dodge support. There's no proof that he dodged it. We're here in court. He's willing to pay for his children. He was in contact with a social worker. He doesn't know why he was behind because everything was being taken out of. As he understands now, I believe he is caught up because they were deducting a higher amount. Now it's down to a 600 amount. Regarding financial abuse, I'm not really sure what she means by that. He's never financially abused her. He was the one who was gone working for 10 or 11 days at a time, a month at a time. And then all of a sudden, he comes home. He's still watching the children. He's paying all the bills. Her money is her money. His money is her money. So she didn't have to pay for anything. He was paying for all of it. He now, as we said, hasn't worked since December 20th, 2023. Bless you, Miss McLean. He hasn't, he's making about $3,000 to $4,000 less a trip. It has to do with the amount. It also has to do with their price of the price of fish and how much they're getting. They get paid less for the fish. He gets paid less money. He gets paid a certain amount, then he gets paid a commission on what they sell their fish for. In regards to his income, he's currently unemployed. He's making $917 a week, or that's $39.73.67 a month. My client's request would be that is used until he starts working again. However, I understand historically he has had a mixture of working in periods of unemployment, working in periods of unemployment. So if the court in the alternative wants to use that, then what we should use is his W-2, the W-2 2023 wages of $96,330, and he did have Miss McLean and I have the same amounts for unemployment, the $12,167. So that would be a gross of $8,027.52, and I have a net of $72,39.36. We would request that anything in terms of child support is effective March 1st, as they filed this in February 23rd. 2024. Of course, I don't object to any reservation. I just don't have anything that shows when another petition was filed. I couldn't make a lot of sense out of Miss Nelson's pay stubs because she states she works she started October 1, and then her pay stub ending 12/15 had a year to date a little over 10, which is far less than 6,500 that Miss McLean states, although 40 hours a week times 37 is the number that Ms. McLean states. So I've only got one pay stub. We have an out-of-date tax return. I realize she hasn't filed. She's not required to file. So I'm not really sure what she makes because I haven't seen October and November's pay stubs. We got one. And so I'm not sure if she's just not working a lot. And also her hourly rate isn't just flat 37. She gets various things depending on what she works. So it's not just clear I make 37. So it's really unclear what it is that she makes. I also look at her financial declaration. She states that she has $98.55 in expenses. She doesn't state that anybody's helping her. She doesn't state that she has any need for anyone to help her. So to me, if she's able to pay $98.55 in expenses, that should be her net. Or in the alternative, utilizing that $65.05 and reserving and then providing us additional pay stubs and tax returns. Based on my client, and if I'm fine with Miss McLean wants some leeway on the financial declaration. My client's upside down about $4,000 every month and is behind in mortgage and personal loans and credit card statements. Again, he hasn't worked. He doesn't have the money to pay. He's not sitting here just twiddling his thumbs. He spoke to his captain. It was either today or yesterday. He should be going back out. I'm just telling the date he's going to go back to work. That's all I'm saying. Miss McLean wanted to know.
Declaration for today's purposes. So,
yeah, so he should be going back in about 12 to 14 days from now, approximately. That is the latest update that we have. My client doesn't have anything. He has no ability to pay attorney's fees and costs. She's the only one who's actually working a full-time job right now. She's able to pay expenses. I do realize that she says she's late on 3 things. But otherwise, she states nobody else is helping her. My client, as stated, has transportation to get himself and the children from any meeting point for any type of visitation. Miss Nelson does state that it's false that my client says that she's late in paying bills, but her own financial declaration says that she hasn't paid the mortgage, her visa, or the car note since January of 2024. So our request is that the court adopt our proposed parenting plan that we filed. And as part of that parenting plan, we do have a request for mental health evaluation, domestic violence, anger management, and substance abuse, with my client being able to give collateral contacts. We are in agreement to appoint a GAL. I think it's absolutely necessary. We even reached out to ask to get a proposed order in and didn't hear back. We asked to adopt our proposed child support worksheets, with either utilizing his unemployment or last year's income. Denied her request for attorney's fees. We would ask that the parties are to communicate via our family wizard, so there's no issues about what was said, when was said, who said it. And then any restraints in terms of testing or this or that should be for both parties. It shouldn't be one-sided. There's 191s alleged against both parties. Any requests for drug testing, UAs, anything like that should be applied to both parties. And then additionally, in regards to the last request would be in regards to when we're transporting the children, we would either ask that the parties are going to share the car seats or they split them 1 and 1, so they're each required to get a new one, since my client is currently not working and doesn't have the ability in which to just go out and all of a sudden buy all of these things, because Alicia has everything of the children, clothes, toys, everything. So for him to have to go buy every single thing new puts him in a financial burden. And so we just ask that, at least on that instance, that they share. Thank you. And then, of course, depending on what visits are ordered, if they are in fact supervised or not, we would request a contact every day, and we have 2 supervisors present in the courtroom who can testify that they're available the entire week and all times. Thank you.
Thank you. Ms. McLean?
Yes. First off, I would note that the suggestion that Mr. Prawl is an involved father, the visitation that was offered, he did not even partake in that. In other words, the request for an established time frame for one phone call or video conference with the children a week, that wasn't good enough for him, so he wasn't going to do anything. The offer of him doing some supervised visitation while he was here, that wasn't good enough for him, so he's not going to do anything. Again, I think that his inaction speaks volumes to his parenting. In regards to the allegations about my client not requesting supervised visitation, initially in her parenting plan, she did file pro se. And if you take a look at her proposed parenting plan that was filed, you'll note that she did argue for 191 factors, including abandonment, neglect, domestic violence, and substance abuse issues for Mr. Prawl. She also indicated that he should not drive without the children. He should abstain from drinking. He needs to obtain a mental health evaluation. And then when you go into the provisions of the parenting plan for pro se litigants, it gives you options of, here's your options: weekends, weekdays, and other. And so after the court entered the protection order, which I believe occurred after she had filed, it is appropriate for her to amend those documents, which she did. And we
Your
are
Honor, I'm going to
asking the
object
court.
as it misstates the testimony. I wasn't referring to the parenting plan. I was referring to her not listing the children on the protection order. Not that she didn't request supervised. It was that she didn't list the children.
Okay. Understood. Go ahead.
So obviously, it's our position that even though the children weren't listed in the protection order carved out once that there was an order in place. And instead, what Mr. Prawl has done is he's used that as a free-for-all to contact my client, berate her during one of the phone calls in violation of that protection order. Obviously, we need to get some orders entered, and we believe that that's appropriate. The last comment that I would make as it relates to finances is there's no documentation verifying that he has brought his child support current. The documentation that you have from our sealed financial source, page 5, shows that as of November 13 of 2023, he was $5,693.92 in child support arrears as to Owen only. That doesn't even include Mia. So he was almost $5,700 in arrears 6 weeks before the end of the year. He claims that he's only been on unemployment since then. It's hard to fathom that he's brought that current, and my client has requested to be able to claim both children on her 2023 taxes as a result.
All right. Well, as I indicated to counsel, outside of the court, as far as my prior involvement in the other case, which does complicate this, I think, to a great degree, because I've got a lot of information about this, this case was not that long ago. On the protection order docket, I did essentially intake a lot of information about this case, a good chunk of which wouldn't be admissible in your normal court rules here. And frankly, I've just got a lot of issues with this case. I think there's a lot of concerns the court has with regards to both parties. Let's start with the guardian ad litem, because I think that's obviously critical. Who's our next three? So Beth Bellows, Karen Lawrence, and Ann Height. Ms. McLean, this is your motion. Who would?
I would strike Ms. Bellows.
Okay. And Ms. Jocelyn?
I apologize, Your Honor. What was who was the second name? I only heard the last part. I didn't.
Karen Lawrence, and then Ann Height would be our third choice.
We'd strike Ann.
Okay, so be Karen Lawrence would be appointed. I'm going to have you do an updated order because I've made some notes on here. We'll set the review, the 30-day review. I'm going to make that May 7th. I think that's due to judicial conference. And that'd be at 1 o'clock instead of 9 as indicated on this order.
Yes.
We'll leave the final on August 6th at 1 o'clock.
All right.
As it relates to paragraph 5, under C, D, and E, that should be for both parties. I think the rest of that order, again, at this juncture, having done, and I spent a great deal of time trying to sort through the financial documents to come up with numbers, and I'm still nowhere near what either of you come up with. At this point, I'm going to, and this is simply an order, a temporary order that can be adjusted if more information comes forward to clarify incomes. I'm going to set child support at $11.25. That's kind of a middle of the road number based on all the different things I have. That's at least within the range, so it'd be half that per child, obviously. Make that effective on March 1. Reserve any back support that may be due going backwards. I'm not making a specific date going back. I'm just saying reserving any prior support prior to March 1.
Okay.
And part of my reasoning for doing that, I'm going to make the fees payable at 50-50 at this juncture, because that's the number that comes out of my calculation at this point. So if we can provide an updated guardian ad litem order with that information in it, then I'll be happy to enter that once I see that.
I would just ask Ms. McLean to send it to us first so we can make sure.
Yeah,
absolutely. And it can be electronically submitted if once both parties have.
That's fine.
That's fine.
Do you want to schedule presentation dates just in case?
I can if you'd like. When do you want to shoot for?
Next Tuesday, the 26th.
If we could do 4/2, could save my client some money. I'm already here. I don't want him to have to pay extra, so long as whatever's ordered for parenting Miss Nelson goes along with.
I'm assuming that all of the orders are enforceable with the court's ruling today, I'm assuming.
Yeah, I just want to make sure if we don't have injury that whatever we have for visits, she's not going to abide by. But it'd be 4/2 would be better. It would be for financially more feasible for my client.
4/2 at 1 o'clock for presentation of all orders. As it relates to, as far as the worksheet goes, I don't know how you want to sort that out as far as numbers, but the temporary support is going to be the 1125.
Okay.
And then the language, whatever languages the state needs in there to be reserved will be included, of course, at this juncture. On the parenting plan, at this point, I'm obviously going to leave the kids with mom, given all the information I have. Under 3, I want reserved on everything with the exception of under the C. That should read, there is a domestic violence protection order entered and then reference the case number and date. Everything else would be reserved, and that's to both.
Hold on. Okay. I'm sorry. You're talking 3A1C?
Correct. 3A1A and B would be reserved for both parties. C just should read that there is a domestic violence protection order that was entered, and I don't have the case number. I do, 232-97708, and reserved as to mother. B would be reserved on both. As far as contact, this is kind of an unusual situation. It sounds like he's going to be going back to Alaska, which will make any kind of in-person contact obviously a challenge. I think what I'm going to do is I'm going to order you 3 times a week, phone or video. I don't know if you counsel can work out a time and dates on that. I am going to order that he have 1 in-person visit supervised, and at this point, I'm going to make that by his sister. There'll be a day visit for up to 6 hours for the 2 children. And then she needs to be present during the entire visit. Line of sight. Neither party is to consume any drugs or alcohol not specifically prescribed for them while the children are in their care. Fine with
I have a clarification, Your Honor. I apologize. I know you said 1 supervised. Is that he's here for the next 12 to 14 days? So can we get something that's
1 at this point?
Just 1. Okay, I just wanted to make sure.
And counsel, I assume you can work out what day that is between the 2 of you that will work for everybody's calendar.
I expect you.
Okay. The limitation that should just read line of sight supervision by the sister at this point.
Your Honor, may I inquire? I know typically when there have been lay supervisors that there's supervision requirements. I do have a set of supervision requirements that I would propose and ask that she sign off, as well as providing notes following the visits so that we have sort of that real-time information.
I can have Ms. Collins sign an oath of supervision and give it to Ms. McLean. I have no problem with that.
Yeah.
Okay, I'll submit that with my proposed parenting plan.
Okay. The condition essentially really is I want line of sight so that she's in charge of them. Under the I'm inclined, given the limitation at this point on the UAs, so, I'm inclined to make that mutual, but that's challenging. I'm thinking at this point, given the very limited contact that's happening in the next 12 days, I'm going to just, I'm going to reserve on that. B will adopt, I'm looking, excuse me, I'm sorry, under paragraph 4,
A2.
2B. So reserve on the drug testing. B would be as written. C should be both, except that's that should be while kids are with them or on a visit, either one.
Or should we say including 8 hours prior to?
Are we on C?
Yeah, it covers
okay.
it.
Yeah, I mean, I would say that needs to apply to both parties.
That's what he said.
That's what I said.
The question is should that be 8 hours prior to or during?
Well, neither of them is to be under the influence of alcohol while they have the kids, so I think that covers it.
Okay. All right.
Both parties, no corporal punishment. I'll leave the E as written at this juncture. That's the licensing and insurance. That seems appropriate given what I know of the case at this point. I'm going to reserve on the B, section B, until I get back guardian ad litem report.
Is that reserved for parties?
I'm sorry?
Because both parties requested eval, so is that reserved for both parties?
I'm reserving under B across the board.
Okay.
And do you want to schedule or add language to provide for the GAL to provide that input prior to the final GAL review?
You can put that in if there's a recommendation for anything. I'm sure it'll come in the interim report, I would assume.
Is the court ordering an interim report? Because that 30-day review is just to make sure that the parties have made contact and paid their fees to the GAL. The order that I submitted to you does not provide for an interim review.
Again, given the fact that I'm going to ask Mr. Prawl one question. He is present. Just simply, how long do you plan? Will you be in Alaska once you go?
I'm out about $40,000.
No, but
trying to.
How long are you going to be up there?
It's kind of up in the air. As long as everything is taken care of with the kids, I would like to do about 4 or 5 months to catch back financially.
Okay, so then you're likely to be there by the time we get that final report back. So I think at this juncture the final report's probably sufficient.
Okay.
And again, that the video or phone visits 3 times a week, that would continue on after he goes back to Alaska. Communication with children, that seems fine. That's the section, I'm on page 10 of Ms. McLean's proposed plan. 15 is fine. Rest that seems fine.
Okay. So as it relates to the phone visitation, there is, so are you anticipating that that's going to be supervised? Or I know that our Family Wizard now offers recorded phone visits. And that's part of their plan now. I don't know if that's something that the court would consider.
I'm not familiar with that, so I don't know what that all involves. Is there a cost to that?
Well, it'd be the normal, from what I understand, it's the normal cost for their plan, which turns out to be about $10 or $12 a month for each party. And if you give me just one moment, I can tell you how many hours their current.
I certainly can discuss it. The issue is going to be when my client's out on a boat, a video call may not always work, right? So if he can't get through on video and if he can't get logged into our Family Wizard, he needs to be able to have an alternative to talk with his children. So if we just relegate it to video and he can't get logged on due to where he is, and he can somehow get a phone call out, he should be able to have a phone call.
So our Family Wizard provides for both video and audio calls. The Essentials plan provides for 45 minutes per month of calls. And the Premium plan, which is $18 a month, provides for unlimited. And that way we would get transcripts and we could access transcripts if there was an issue.
If I may, Your Honor, I'm, being on a boat in the ocean, my bandwidth is very, very low on the limited internet that we do get. You add weather, you add the direction that the boat is facing, it changes the signal. Sometimes I can't even get through on the telephone. Okay. Let alone an internet device. So
let's do this. And Ms. Jocelyn, you'd requested the My Family Wizards. I think that's appropriate given the circumstances of the case. I do want language in there that if there is an issue that makes, and I'm not sure if that works purely over the internet or it's available as a regular phone call, which sometimes is better connection. If that's not available or doesn't work, he would need to then send a text that he's going to call instead. But primarily, I would expect they'd use the program as long as it's available.
Okay.
However you want to structure that. On the temporary, did I miss anything on the family, on that parenting plan? I think that covered everything.
The only thing that as it relates to the child support is the 2023 taxes.
I think given where we're at, I'm going to grant her those two for this year. And I'm going to defer on attorney's fees. That's the reserve on that, essentially. That's a request that can be made later, but at this point, I'll leave it where it's at.
Okay.
And I had one question, Your Honor. When you said 50-50, was that just into GAL or is that also proportional share is 50-50?
It's going to work out to that on the child support the way I was coming at. It's kind of an average of all the different numbers put together. So at least at this point, that may change if in discovery we get better information about both parties' incomes.
Okay.
And I don't know, Ms. Looney, I don't know if I gave you an opportunity to weigh in on any of this. Are you comfortable with from the state's position? Did I miss anything?
No, Your Honor. We're involved just as to medical support, and I did review the proposed medical language from Ms. McLean's order, and that would be appropriate as it is. It does seem appropriate to use the incomes as Your Honor has determined them. There was a lot of conflicting information. I was struggling as well. But after hearing the explanations, it does seem that those incomes would be appropriate for the proportional shares.
All right. So that's what we'll do on that. I didn't want to, you're hiding up there in the corner, so sorry about that.
So so what are the numbers that the court is using as far as incomes that I'm supposed to put on the worksheet?
Well, that's a good question. It's kind of an average of all the different ones I had in front of me. So my suspicion would be, and I don't know if support calc will let you do that, but if you can just fill one out that has the amount in it that would based on a 50-50 number.
So you want the same net income for both parties?
I didn't catch that.
You want the same net income for both parties?
I think that's going to be the easiest way to make the worksheets work. And
you want an amount that equates to about $11.25 a month.
Correct. Because I came up with it when I worked the numbers and averaged out, I came up with $22.50 as the amount to be split, and so by cutting that in half, it'd be $11.25.
Okay. Or the alternative would be for the court just to reserve on the determination of their net incomes, not file worksheets.
I'm fine with that too. I don't know that we need to have a worksheet filed in order to on a temporary basis, given what we're trying to do.
Counsel, acceptable?
It's acceptable that we just do the order that says 50-50 in the what you just said, Ms. McLean. Sorry, the words aren't coming out. That's acceptable since we don't know.
Okay. I'm looking at the proposed temporary order, and again, I'm going to reserve on fees. I'm going to obviously the residential schedule is fine. I am going to limit taking the kids out of Washington State. We'll appoint a guardian. You might want to cross out work. I can just cross that out on this order, unless you want to do. Do you want to do a new order?
I'll do a new order.
Just put temporary child support order, cross out worksheets.
Okay.
B is fine under 5.
Reserve on
6.
6.
And everything else looks fine.
Okay. I'll submit new orders, and assuming that they're agreeable to Ms. Joslin and Ms. Looney, we can arrange to have you folks e-sign, and then we can submit them ex parte to the court and strike the presentation.
Very good. Great. And those can be, if they're already signed off, those can be submitted electronically to me. So
thank you.
State as well.
Okay. Okay. Thank you.
All right, you're welcome.
Thank you, Your Honor.
Welcome.
Thank you, Your Honor.
You're welcome. I believe that's everything we have, so we will be adjourning.